Hello everyone, welcome to Jagruthi YouTube channel. In this video, I wish to take up the topic Advocates Protection Bill 2021. In this video, I will be explaining you important points of the bill along with the explanation. The whole video will be in English language. Then moving on with the contents of the video, general introduction to the topic, overview of the bill and then important points of the bill along with the explanation. Now, the objects and reasons for enacting this bill. To protect the advocates from the assaults, criminal force, intimidation and threats while discharging their professional duties as contemplated under law. Secondly, to protect the advocates from the threat of malicious and frivolous prosecution by the rival parties. Thirdly, to provide social securities to the advocates and to ensure basic and minimum necessities of their lives. Then, this bill is in consonance with the 8th United Nations Congress Declaration on the Prevention of the Crime and the Treatment of Offenders, where it has adopted the basic principles on the role of lawyers, and also to this declaration India was a participant. Clause 16 to 18 of the declaration deals with the guarantees for the functioning of the lawyer, which are as follows. Clause 16 states that government shall ensure that lawyers are able to perform their professional services or functions without intimidation, hindrance, harassment or improper interference. Clause 17 of the said declaration states that where the security of the lawyers is threatened as a result of discharging their duty, they shall be adequately safeguarded by the authorities. Then, overview of the bill. This bill has totally 16 sections touching upon various aspects such as police protection to the advocates, punishments for offences against advocates, and also protection from illegal arrests, etc. The bill states that it extends to the whole of India. And then, advocate under this bill states that it will have the same meaning as provided under Section 2 Clause 1 Clause A of the Advocates Act 1961. According to Section 2 Clause 1 Clause A of the Advocates Act, advocate means an advocate entered in any role under the provisions of Advocates Act. Then, important points of the bill. Acts of violence under this bill refers to the acts committed by any person against an advocate with the intent to prejudice or derail the process of impartial and fair and fearless conduct of any litigation before any court, tribunal or any authority, and also it includes the following: harassment, coercion, assault, criminal force or threat impacting the living or working conditions of such advocates, and then harm, injury, hurt, either grievous or simple, or dangerous to the life of the advocates, either within the premises of the courts or otherwise. Thirdly, coercion by whatsoever means of an advocate to reveal or part with his privileged communication. Fourthly, coercion by whatsoever means of an advocate not to represent or to withdraw his wakalat or appearance to act, plead or appear on behalf of a client before any court or tribunal or authority. Fifthly, loss or damage to any property or documents or materials which advocate is bound to hold under law. 6. Use of derogatory language during the course of judicial and quasi-judicial proceedings. Nature of offence and jurisdiction of court. According to Section 5 of the Act, notwithstanding anything contained in the Code of Criminal Procedure Code, that is CRPC 1973, it states that an offence punishable under Section 3 of the Act shall be cognizable and non-bailable. Firstly, it is cognizable and non-bailable. Secondly, any case registered under Section 3 shall be investigated by a police officer not below the rank of Superintendent of Police. Thirdly, investigation of a case under Section 3 shall be completed within a period of 30 days from the date of registration of FIR, and then it states that no court inferior to that of a district or session judge shall try an offence punishable under this section, and also in any enquiry or trial of a case under Section 3, the proceedings shall be held as expeditiously as possible. Generally, it states that the trial or enquiry is to be concluded within a period of 1 year. And then the next important provision in this bill is regarding the police protection to the advocates. This is mentioned in Section 7 of the bill. This states that any advocate who is under the threat of being a victim of an act of violence shall be entitled to the police protection. For this, he has to make an application before the High Court of the state within which he is registered to practice law. Every High Court shall, before passing orders under the Section 7 Clause 1, scrutinize the personal antecedents of such advocate, including his criminal record, etc. And also, this section states that whenever the police security is provided to the advocate, the Superintendent of Police shall, before taking a decision to withdraw or reduce or discontinue such security, refer the matter to the registrar of the district court in case if an advocate is practicing in the district court, and also to the High Court if he is practicing in the High Court and the Supreme Court as the case may be. And also, no decision shall be taken by the Superintendent of Police to withdraw or reduce or discontinue the security provided to the advocate unless a notice of 1 week is given to the advocate in this regard. And then, constituting a redressal committee. This is one of the important provision in this bill. According to the bill, a 3-member committee for redressal of grievances of advocates and the bar associations has been provided at each level, that is district court, high courts and the supreme courts. The head of the committee is to be the head of the judiciary, that is district judge for a district level, chief justice or his nominee of a high court at the high court level, and the chief justice of India or his nominee for the Supreme Court of India. The appointment of the remaining 2 members is to be done by the nomination by the respective bar councils. The president of the bar council shall be the special invitee at the meetings of the redressal committee. Then, protection against suit. No suit is to be initiated against an advocate who has been working in good faith. Communications between the advocates and their clients must be respected and the confidentiality must to be protected. And then, protection against the arrest and prosecution. This is one of the important section of the Advocates Protection Bill 2021. According to section 11, it states that no police officer shall arrest an advocate and or investigate a case against an advocate without the specific order of the Chief Judicial Magistrate. Okay, then social security. This is another important provision made in this bill. This bill proposes that the state and central government have to make provisions to provide financial assistance to all needy advocates of the country in unforeseen circumstances such as natural disasters or epidemics such as COVID-19. A minimum of rupees 15,000 every month shall be provided to all these advocates, and also the bill states that the central government must provide insurance schemes to the advocates. Then, public servant obtaining the privileged communication from legal practitioner. According to section 12 of the bill, it states that where any public servant having power to investigation or arrest under CRPC is found in possession or found to use his investigation in any such privileged communication or material which can be shown to be obtained from an advocate, it shall be presumed that such privileged communication or material was obtained by such public servant by coercion. So this states that any public servant who obtains the privileged communication between the advocate or his client is deemed to be obtained by the coercion. Next, moving on with the punishment. Section 3 talks about punishment. Whoever commits or abets the commission of an act of violence except grievous hurt covered by subsection 2 hereunder against an advocate shall be punishable with an imprisonment for a term which shall not be less than 6 months but which may extend to 5 years and with a fine up to 1 lakh rupees. Secondly, whoever having already been convicted of an offence under this act is convicted for a second or subsequent offence shall be punishable with imprisonment for a term which shall not be less than 2 years but which may extend to 10 years and fine which shall not be less than 10 lakh rupees. Compensation. In addition to the punishment provided for an offence under section 3 of the bill, the person so convicted shall also be liable to pay by way of compensation, and also such amount may be determined by the court for causing any act of violence against any advocate. This also states that in case of any damage or property or loss caused to the advocate, the compensation payable shall be twice the amount of the fair market value of the damaged property or loss caused, and also as may be determined by the court. Thank you so much for watching this video. If you like this video, please do like, share and subscribe.